I'm Sam Lister from the Chartered Institute of Housing. We're a professional body for people who work in housing, and I work in the policy team, and I've been involved in the policy issues around private renting and benefits and migrants' rights as well for far too long, really. But there we go. We, and you'll see this when I get into the presentation. We've produced a resource for migrant renters about housing rights and your rights to access to housing, and I'll touch on that. It's on the website. It's a free resource. It's split into two halves. So there's a side for people, service users themselves, and there's a side for administrators, for councils and other people and DWP who are making these decisions. We found quite a long time ago that there was a lot of misunderstanding about what the rules were, and they weren't being interpreted correctly. So this was to, give people more confidence that they about what their rights were, so they could assert them, and also to help local authorities, kind of make better decisions as well. So get it right in hopefully 90% of the cases. Yeah. So housing rights for migrants. Tilly opened up by saying I'm going to cover renters' rights. What I'm not going to cover is all the stuff around your rights as a tenant and that kind of stuff. I'm sure there are plenty of other generation rent resources around that and webinars around that as well. So I'm not going to be covering things, like what rent you pay, whether you can challenge it, what happens if you've got disrepair. Quite happy to deal with some of those in questions afterwards as well. The resource I talked about also deals with those issues. It's got a private rented section on it as well. But I'm going to be talking about access to housing. So that's access to private renting. And it's also about access to homelessness and benefit services should you ever need them as well. So help with rent, that is, through benefits. Right, let's try and move this on. Yeah, okay. So this is the website I was talking about. It's called, there's the web address there. It's called housingrights.info, and you can go in there, and there's the two halves. You can click on the buttons, and then it will take you through what your rights are according to your status. And I'm going to be talking about status of for most of the presentation, because that largely determines what rights you've got. So nearly all of the rights that I'm talking about, so access to private renting in England, homelessness should you need it, and benefits to help pay your rent, depend on your access is around defined in terms of whether or not you're subject to immigration control. And just be aware there are kind of three different ways of defining immigration control. There's the actual real one, which is the most important one, which determines whether you can actually be here or not, and that's in the Immigration Act of 1971, and that's basically the means by which entry, right to live in the UK, right to settle, is regulated. As you know, you have to apply for leave to come here, and and what sort of leave you get depends on what you're applying to come here to do. So whether it's to work, to settle, perhaps with a UK partner or something like that, or to study. And then there are the the rights and access to housing use immigration control as a means to either blocking or giving you access, but they use slightly different definitions for each. So you can't assume that just say, for example, you've got access to one of these, then your immigration status is necessarily safe. So yeah, the definitions are slightly different. So the proper definition is, yeah, that you require somebody who's subject to immigration control is somebody who requires permission to enter. Permission is called leave to enter, live, or settle in the UK, and there are only two groups of people who that doesn't apply to, in terms of people who are British or not. And then the homelessness, anybody who requires leave to enter is defined as subject to immigration control and therefore blocked. And benefits uses a slightly lesser threshold. So that's anybody who requires leave who doesn't have it, or who has leave with a no public funds condition. So, you know, some people, that implies obviously that some people with leave have access to benefits, whereas they might not otherwise. Okay, so what's leave? Leave is granted by immigration officers. So I'm assuming that some of you, most of you, because you're here, you'll have had some experience of this. So it's granted by immigration officers according to the immigration rules. That's just a set of rules by which they have to make their decisions. It's basically a type of law. And there are different categories of leave, but basically three kinds of different things that may impinge on your status as to rent or to access housing services. So leave can be open-ended, and that's called indefinite leave. So there's no time limit on it. So if you're settled, then you'll have indefinite leave, or it can be for a fixed period, and often that's 30 months. So people who are coming here to settle, perhaps they're marrying a UK partner, they'll be given 2 blocks of 30 months, and they have to apply after the end of each or towards the end of each and get a new block. And then leave can be with or without conditions. So indefinite leave doesn't normally have conditions with it, but it can do. And then fixed leave, limited leave for a time period usually does, and that normally includes a no public funds condition. And some people can be granted leave, but only on where they've got an undertaking from a sponsor. A sponsor is basically a guarantor that they will, and the guarantor says that they will accommodate and provide for their maintenance if they're without funds at all. So indefinite leave to remain, that's when you can then, you've got permission to be here without any conditions, and that's also sometimes called settled status. And any right to, some of these rights to housing or benefits may require a change in your status. So people from Hong Kong, British nationals from Hong Kong, for example, get leave with a no public funds condition. If you wanted to access benefits, then you'd need to change your status. You do that before you apply for your services, and always do that with a regulated advisor. So that's the Office of Immigration Services Commissioner, and you can click on that link there, and that will tell you any advisors near you, what level they're at. It's different levels depending on how complex your case is, and whether it's free or not, or whether you need to pay fees for it. So who does it affect? Immigration control. So the two people who aren't subject to immigration control are British citizens, not surprisingly, and certain Commonwealth citizens who arrived here before 1973. They have what's called the right of abode, which just means they're basically free from immigration control. Some of those Commonwealth citizens that are here had problems. You'll have probably heard of the Windrush scandal. That's because you didn't need documentation. You only needed your passport before then. And they hadn't got any kind of proof at all that they, even though that was their status, they couldn't prove it. And that's where that scandal came from. Everyone else requires, any other kind of foreign national needs leave, permission to enter or remain. And the only exception for that is Irish citizens who get automatically given leave. They don't have to apply for leave. It's just assumed that they get it, except in very extreme cases. Okay, so you've kind of got this hierarchy of status where at the top, you've got unrestricted access to services, and then going down, generally speaking, so if you've got anything down to 7, so that's leave with access to public funds, then you're going to be able to access the rights that I'm talking about. But that doesn't mean that you won't have problems. So there are problems around proof and documentation. So as I said, just a few seconds ago, Commonwealth citizens with the right of abode that had problems with actually proving their status. And even if you're free from some of this stuff, you still might need to prove where you're from, which is where you'll encounter the controls and the questions and the requests for documents, that kind of stuff. And then it's 8, 9, and 10. So the people who don't have leave when they arrive here. Temporary admission, that's where people have been given permission to apply for leave, but they don't have leave whilst they're here. So they're just technically not breaking the law. Okay, so and then there's access to services. This kind of works the other way around. So the ones at the top there, you need kind of the higher level of status in order to access. And as you go down, you don't necessarily need a higher status to get those. So if you're getting homelessness assistance, then you'll be able to apply for the other things as well. Don't worry about the other ones. They're kind of technical. There are some people who are caught in the immigration system who don't have access to funds, but might have access to other services. So the one I'm going to talk about most is the private rented tenancy and the right to rent. And this applies in England. It doesn't apply in Scotland and Wales. So this is your right to rent. So what's the right to rent? It's part of this, what the Home Office used to call the hostile environment, and have now rebranded the compliant environment because it sounds nicer. It's actually the same thing. And the idea of that is to deprive undocumented migrants access to essential services. So to try and force them to leave or to make life uncomfortable for them. So that includes access to things like a bank account, a driving license, renting a home, NHS services and welfare benefits. So it becomes very difficult to live here without having your immigration status sorted out. And who does this apply to? So these are landlords have become part of the policing system for the Home Office. So anybody who lets property or who takes people in on a subletting basis, so that would include tenants or people accepting lodgers, has a responsibility to do the checks essentially for the Home Office and prove that they've done that. And if they haven't, and it turns out that the person there doesn't have the correct status to be able to rent, then the consequences fall on the landlord as well as the tenant. So it's document checks on prospective tenants and occupiers, and repeat checks on occupiers whose rights are time limited. So if you've been given limited leave, for example, say you've been given 2.5 years leave, then the landlord is expected to do a repeat check. So they on the initial check, they should find out when your leave expires and then do a further check before it does so. Landlords who fail to comply at risk of civil and criminal penalties. And it applies to all the adults, including those who are liable to actually pay the rent, but also anybody else living in the property and anybody else who's not named in the aggrievement, but could live there by permission of the tenant. The landlord has a defence if they made reasonable inquiries about the occupiers who might be living there beforehand when they did their initial checks. So how does it work? Before moving in, the landlord must check everyone who's a prospective tenant or going to occupy. So that might be, kind of spouse or other family members of people aged 18 or over, and make copies of the documents or ask for proof. Now it's mainly using the online checking service, and the landlord should ask for proof of age if they suspect that so if the tenant tries to get around and say, well, they're only 16 or whatever, so you don't need to check them, the landlord should still ask for proof. Okay, so these apply where you have a time limited right to rent. So your right to rent is basically your leave, the permission that you've been given, and so a time limited right to rent is one that's where you've got a leave for a fixed period. If you've got indefinite leave, then you've got an open-ended right to rent, but of course the landlord still needs to check that, and they need to check it before 28 days before your the eligibility period applies. So they have to do this once every year, or if your leave is coming up as well, they need to do it then again for that. I'm aware there'll be people from different kind of migrant groups, so EUSS, so the EU settlement scheme. So these are people who entered the UK whilst it was still in the European Union, and applied to stay here afterwards through the settlement scheme. They don't get actually any physical documentation to prove that, but they can prove that through the online service, so that they'll be given, those who applied to stay here will be given either EU settled status or EU pre-settled status. So EU settled status is just the same as the same immigration status as as ordinary settled status, so it's indefinite leave. And the landlord can ask to view the tenant's right to rent. So one way the tenant can do that is get a share code through the through the website, and that's the simplest way of doing that. I think now most physical document checks have gone out, and you have to do that through the landlord. The landlord has to do that through the checking service themselves. So when these rules were first brought in, the landlord could look at the documents, take photocopies. Of course, Home Office, being paranoid, were worried about forged documents and that kind of stuff. So that most of it has to be done through the Home Office service themselves now, who check the documents, or you can do it through the right to rent share codes. Okay, so allocations and homelessness. So you must be not subject to immigration control, and that means anybody who requires leave, so that's pretty much any foreign national, doesn't get access to homelessness service unless they're in a prescribed class. So it rules everybody out, and then creates a set of rules which specify which people can still apply. So that's what those prescribed classes are, and I'll go over some of those. And you must also be habitually resident, and this rule actually applies to everybody, also applies to British citizens. So you need to show that this is the place where you've made your home. And the reason that applies to everybody is because, you know, people can get British citizenship even if they've not lived here their lives. So, for example, you know, typically through their parents. So their parents might have emigrated, but they can get British citizenship by descent. They couldn't just arrive then in the country, you know, not having lived here at all later on, and then claim services. So that's what that rule does, and that applies to everybody. So I haven't done all of these, but these are some of the eligible classes. So these are the people who are written back in, and even though they're subject to immigration control, have access to services. The ones that this group is most likely to be in are people with indefinite leave, provided you're not sponsored immigrant and you're habitually resident. People from Hong Kong who've applied and had their public funds status lifted, and then various other people from Ukraine as well, who's now a very big group, and people who are EU nationals, they actually fall under number 3. So if they've got indefinite leave, and any other kind, or so if they've got EU settled status, or if they've got pre-settled status, they're exempt from these rules. Well, you'll still have to show you're habitually resident. How does this work then if you're a mixed household? So some of you, you know, you might have married somebody who's British, for example. So you've got leave, they're British, so they don't need it and they're okay, become homeless. What then happens is, if you're an ineligible person, then the homelessness checks and rights to accommodation are done on the basis as if you weren't there. So, for example, in deciding whether you've got priority need as a homeless person, priority need is given to mainly to households with children. If all of those children are people who are subject to immigration control, then they'll accept the British person as the applicant and say, yeah, you can apply, but you won't get priority need, because that's only on the basis of the ineligible people. So it gets quite complicated, but that's all on the website about when you've got mixed families as well, so you can go through that. And then universal credit and housing benefit. So universal credit is the main benefit now for people of working age. You must not be subject to immigration control. And that, again, that, as I said at the start, that means that's defined in a slightly different way. So that basically means anybody who has got leave with a no public funds condition attached, you'll be excluded. If you've got leave and it hasn't got a no public funds condition, then you're okay. You've got access, provided you're not a sponsored migrant, and you'll have to be habitually resident on the fact. So that's just means you've made your home here, and some people are exempt from that because we've decided to, kind of give special status for those. So Ukrainians, for example, who've fled the war, on arriving here immediately, they'd be able to access homelessness services if they did need it. So that's obviously that's a policy decision decided by government, and they made the rules around that. And EU nationals are who have pre-settled status and who are in paid work are also exempt from that test as well. So they're basically the people who are EU nationals who arrived here before 2021 but haven't lived here for 5 years yet. Okay, and yeah, then you have rules around benefits, a bit like kind of with mixed households. So it depends on who the claimant is. You have to be very careful with these and get advice beforehand. In universal credit, if a couple makes a claim, and you make a claim jointly, usually, and you've got one British and one non-British person, then that would be the British person can make a claim, but they'll only be assessed on they'll be awarded benefit on the basis that they're single. I wouldn't advise anybody to do that anyway. Get your immigration advice first before you do that, because it may affect when you come to renew your status, it may then affect that. And with housing benefit, there's only one claimant. So whoever it is, the British person could claim for both, but that claim, including the other person, would count as public funds, and therefore you'd be in breach of your conditions. So again, don't do that without getting advice, immigration advice beforehand. The local authority who administer housing benefit don't have to, but they could report that to the Home Office, and obviously you don't want that happening. Okay, don't know why I did that. It was a bit odd. Right, so a little bit more about habitual residence. Generally, this only disqualifies you for a short period. So it's just to establish that this is where you've made your home. And there are various things that, kind of prove that. The disqualification period lies somewhere between 1 and 3 months. So it's not that long. If you go away and then come back again, then you may have to go through a new qualifying period. That doesn't count for things like holidays. Obviously, you're still resident here. If you go on holiday and you come back. But in any other case, if you go back abroad and work there, for example, and then come back to the UK, you may then have to establish habitual residence before you qualify.